Mitch from Basham Shaw, wanting to fill everyone in today on waivers. I hinted at this at my video on the process of deportation proceedings last week. If you're watching this video, please like our Facebook page, reach out to us through our website, www.bashamshah, BASHYAMSHAH.com. You can reach out to me directly via email, Allison, ALLISON, at bashamshah.com. We are, expanding our information out there. We have, through our Facebook, we've got a blog that we're updating very frequently. We have an entire page dedicated to COVID-19 resources and information that you need to know. So like us, check out our website. You can subscribe to our newsletter there to stay most up to date on our information. So jumping into waivers, I'm going to talk about 3 different groups of waivers today: non-immigrant visa waivers, general inadmissibility waivers for green card purposes, and deportation waivers for those who've previously been deported. So right now we're getting a lot of questions about non-immigrant visa waivers. I'm sure you've seen news on our page. There have been quite a few people with F1 visas revoked for issues with their employer, those on OPT, and wanting to know what their options may be to return in a different visa status, things like that. So for the non-immigrant visa, any non-immigrant visa that you may be eligible for, if you have a ground of inadmissibility, remember from our video last time, a ground of inadmissibility is any means under our Immigration and Nationality Law, the INA, the Immigration and Nationality Act, that states you are not eligible for status in the United States. Can be for any reason. There are many grounds of inadmissibility, ranging from criminal grounds, health-related grounds, for not having required vaccinations, things of that nature, going into prior immigration violations, having been deported, having been involved in drug trafficking, alien smuggling, terrorism grounds. There are many, many grounds. So I'm not going to talk about all the grounds of inadmissibility. I'm just going to hit on some of the major ones, but focus rather, if you're found to be inadmissible to the country, what are your options moving forward? So talking about non-immigrant visa waivers, there is one waiver. Traditionally, it's filed with the U.S. consulate where you are seeking the visa. You can file them simultaneously, or if you haven't yet been found or deemed inadmissible, you file it after the fact, after your visa is denied. In some circumstances, you can file with CBP, but again, I'm not focusing on the where, hows, and whos. I'm focusing on the qualifications. So the non-immigrant visa waiver is actually a very broad waiver. It waives almost any ground of inadmissibility aside from a couple major things. One being the Nazi ground of inadmissibility, which obviously very few people out there were still a part of Nazi Germany, but that is not waivable. Having committed serious crimes and any grounds of terrorism that deem you inadmissible. So those are the only 3 things that are not waivable. Everything else, though, is, which makes it a very broad waiver. They're looking at various factors in terms of, and I have them written down. I'm reading my notes just to make sure that I don't miss anything. So these factors, they're going to look at in terms of whether to decide it's a discretionary waiver. So in terms of to decide, they want to see the reasons behind why you're deemed inadmissible. What conduct resulted in you being found inadmissible? Why are you wanting to come back to the United States or come to the United States for the first time? What are the reasons for your travel? What positive or negative effect will your admission into the United States in this visa category have on U.S. public interest? So they're not concerned about how granting this visa is going to affect you positively, but how are you going to contribute to the United States public interest? They're also going to consider, was this a single isolated incident, or were these a series of incidences, just making a lot of bad decisions maybe in your younger years? What action caused you to be deemed inadmissible, or actions? And finally, is there any evidence in your file? Are you presenting any evidence that you've been reformed or rehabilitated from this prior act? That's most common in a criminal ground where you may have a criminal past, but you've since sought treatment or have not had criminal history for some time. So again, as I said, you traditionally file for this with the U.S. consulate in the country where you're filing for the visa. These waivers can take a couple months to process. It really does depend on the individual consulate, and in the Trump administration, it is harder and harder to get these visas approved, or these waivers approved these days. We are living in a difficult anti-immigrant administration right now, and a lot of times it's easier for them to focus on the negative factors than the positive ones. So we highly recommend that you work with an immigration attorney. Keeping in mind, as I'm talking about these different waivers, I'm speaking very generally about what the factors are. I'm not getting into evidence, how to prove it, because these are all determined on such a case by case basis that you're really doing yourself a disservice to simply watch this video and say, oh, I know how to prove that, and go ahead and file on your own. Please give us a call. I gave you my email address, and I'll repeat my email address at the end of this video, but reach out to me directly. We can schedule a consultation and really talk about your case. I handle a lot of waiver cases. I enjoy doing waivers because they allow attorneys to be very creative with legal arguments, because no waiver case is going to be identical to another one. Each case is very much dependent on your individual factors, your prior conduct that led you to be found inadmissible, and what your circumstances are for why you want to seek to re-enter the United States. So please give me a call. I'm happy to go over your individual circumstances and determine what you are or are not eligible for, and what evidence you should look to put together for the waiver. Moving on to waivers for either an adjustment of status or consular processing when seeking lawful permanent resident status. So whether you are going through consular processing at the U.S. consulate abroad or in the United States filing for an adjustment of status, if you are found inadmissible, again, for any number of reasons, there may be a waiver eligible. Unlike the NIV waiver, there are a lot less things waivable when we are talking about permanent residency status. So something you cannot waive: any findings of marriage fraud. You cannot waive if you've ever made a false claim to U.S. citizen. You cannot waive any drug convictions aside from a single conviction for possession of less than 30 grams of marijuana. You cannot waive any aggravated felony convictions, any terrorism charges, Nazi, serious crimes, a lot of things that are covered in the NIV waiver, but it is very much expanded. So you are limited. Now, in addition, various inadmissibilities in the green card status have different standards. So not each waiver looks like. They're all filed on the same form, but the legal standard, the evidence required, and the legal analysis that you're going to do is very different depending on what ground of inadmissibility is found against you. And sometimes you need multiple waivers, again, all filed on the same form, where you're talking about different legal standards. So I'm going to hit on four major waivers, the four most common waivers that I see in my practice, talk about what those legal standards are. The first one is unlawful presence. So for those individuals who enter the country, whether they enter lawfully or without inspection, and then when they need to leave the country to go pursue consular processing, by leaving, they may be triggering a 3 or 10-year unlawful presence bar. The legal standard to qualify for that waiver is being able to demonstrate that your LPR, lawful permanent resident, or U.S. citizen spouse or parent would suffer extreme hardship, either in the event that you are separated for that 3 or 10-year bar, and they will suffer hardship here in the United States with you abroad in your home country waiting out that bar, or in the event of their relocation to your home country. So again, the standard is extreme hardship only to your spouse or parent. It does not include hardship to children. One thing unique about the unlawful presence ground of inadmissibility, there is the possibility to file what's called the provisional waiver, the I-601A. That is if your only ground of inadmissibility is unlawful presence, and you're here in the United States, you file for it before you depart for consular processing. That way it eliminates wait time with you out in your home country. Now, as early as Tuesday, it was announced by the Trump administration they are seeking to change the regulation of the provisional waiver that was expanded under President Obama. They have not yet announced what those changes will be, so stay glued here. If you need that type of waiver, a loved one needs your waiver, I will kind of be updating as we get more information about that, because we don't yet know what they're seeking to do. Another common waiver is immigration fraud. So, immigration fraud is making any sort of material misrepresentation or leaving out information can even be considered fraud, or presenting fake or fraudulent documentation to an immigration officer for admission, for a benefit, anything here. Just a very broad definition of what fraud is. The legal standards for obtaining the waiver are the same as the unlawful presence waiver. You need to prove extreme hardship to your U.S. citizen or lawful permanent resident spouse or parent. It does not include children. And you file that, again, the I-601 form with USCIS. Even if you're abroad, it is filed with USCIS. They have, in the past, you were able to file with the U.S. consulates directly. They have since changed that practice, and you file it with USCIS here in the States while you're waiting for that waiver to be processed abroad. Another common waiver, criminal waiver. Legal standards are a little bit different this time. So this is if you commit a crime, have a conviction, or admit to committing a crime that deems you admissible. This does include now hardship. It's the same standard, extreme hardship, but it includes your children this time. So you need to demonstrate that your U.S. citizen or lawful permanent resident spouse, parents, or child would suffer extreme hardship if the waiver is not granted due to your separation from each other or that individual's relocation to the United States. There is an exception to that. If the crime in question happened more than 15 years ago, the standard changes to that of discretion and rehabilitation. So depending on the length of the crime against you, the standard has changed. It may be easier to get that waiver. Finally, one last waiver that I want to mention, because this has popped up much more recently over the past years in the Trump administration, is alien smuggling. So there's a very broad definition of what alien smuggling is in the United States. Even if you're not physically helping cross the border illegally, it can include sending money to a coyote or a smuggler, picking someone up at the border after they've engaged in smuggling. Lots of different activities can involve that. And this is a very limited waiver. So this waiver is only available if you have a green card and they're trying to strip that green card from you due to alien smuggling, or in a family-based petition process. So these other waivers I'm talking about generally are eligible for any green card applicant, whether it be through a family petition, an employment petition, or the diversity visa, so long as you have that qualifying relative. The alien smuggling waiver is only available to those applying for residency through a family-based petition, so long as it is not a sibling category. So if your U.S. citizen sibling is petitioning you and you've previously engaged in alien smuggling, you are out of luck. Any other visa category, family petition categories, you can apply. Only if the person you smuggled, the person you helped smuggle, was your spouse, parent, or son or daughter. Okay, so if you helped anyone else, a cousin, a grandparent, a sibling even, you are out of luck. So again, this waiver is very limited. The standard, though, is pure discretion, as well as for humanitarian purposes to ensure family unity, and because it's in the public interest that this waiver be granted. So you just need to prove one of those factors, also that you're deserving of positive discretion. So again, this is a very, very quick view at some of these waivers. I hope that you reach out to me and give me a call. We can sit down and talk. If you're worried you have a ground of inadmissibility, if USCIS has told you, or the consulate, if a visa has been revoked, give me a call. Switching gears one more time to talk about waivers available to those who have been deported, so or physically removed from the country. As I said last time, we don't deport people anymore, we remove them, because that sounds a little bit nicer. And by we, of course, the federal government, not myself. So there are various waivers. It depends what area of law you were removed or deported from. It's really hard to summarize in the purposes of this video, but suffice it to say, these types of waivers are based on pure discretion. So in some contexts, they're a little bit easier to obtain than various grounds of inadmissibility at times, having previously been deported, because they're looking at positive and negative factors. So some positive factors include length of time you've been in the United States, specifically if that was in lawful status, any military service, having children, having those that depend on you in the United States, payment of taxes, proof of lawful employment, proof of property, and showing that you contribute to society. Negative factors, on the other hand, include a continued disdain for our immigration laws, particularly those who have crossed the border, returned numerous times unlawfully, having an expansive criminal record. One thing the Trump administration is really harping on right now for the undocumented community is having multiple convictions for driving without a license or driving with a revoked license, even though those, by North Carolina law standards, are very minor traffic infractions. They're harping on those now and using those as negative discretionary factors. Where you file for a deportation ground waiver depends on where you are in the. Sometimes, if you're in the United States looking to waive that in advance, you file it here with USCIS. Sometimes you'll file it with CBP. Again, it really depends on your individual factors, how and when you were deported, by what court, or if it was an expedited removal by CBP. There's a lot of different factors there. So suffice it to say, it's a very quick overview of these waivers that I'm giving, but please reach out to us if you have any questions or concerns about waivers. You need one, you want more information. I'm happy to sit down and talk to you. Again, my email is Allison, Allison, @bashamshaw.com. Check out our Facebook page. We are constantly updating with information. You can also go to our website, bashamshaw.com, to subscribe to our newsletter, check out our blog, and stay up to date with the most recent COVID-19 policies and practices in the various immigration agencies. Thanks so much for checking into this video today, and check back for more content soon. Have a great day.